substantial increases in the amount paid to the claimants over and above that from the compensation fund. It is envisaged that the settlement trust will work closely with the Department of Health and will cover the cost of administration and services to the claimants and the ex-mine workers. This is highly commendable. Today in this press conference, we are coming to inform South Africans about two major issues that are going to impact on the lives of mine workers and ex-mine workers. The first issue, as already stated, is this historic settlement of South Africa's largest class action that ever took place in the mining sector. And the details are going to be given after I've spoken. So I'll leave that one. But the second issue on which I would like to expand in length is to inform South Africans about the outcome, the results, or progress, if you like, of our visionary process that started 4 years ago when in the Department of Health, I appointed Dr. Berry Kisnasamy as the Compensation Commissioner for Occupational Diseases, the CCOD. As some of you might know, especially the health journalists, the state has two compensation mechanisms for workers who get afflicted by occupational diseases, injuries and hazards in the place of work. The first mechanism is through a law called COIDA, or Compensation of Occupational Injuries and Diseases Act. This falls under the Department of Labor and is designed to compensate all work-related diseases and injuries except lung and heart disease that occur in the mines. The second state mechanism of compensation is through an act called ODMA, or Occupational Diseases in Mines and Works Act. This act compensates through the Compensation Commissioner for Occupational Diseases, which I've already mentioned, was newly appointed in 2014. It deals with any lung or heart disease that occur in the mines and works only. And by works, we mean quarries, smelters, and refineries of commodities. The state compensation mechanism has been ailing very seriously since the mid-1970s. This ODMA Act I've mentioned, the Occupational Disease in Mines and Works Act, which was enacted in 1973, was meant to expand compensation services and medical assessment services to black mine workers for the first time in the history of mining in our country. I'm saying for the first time because before that, the only act that happened was enacted in 1912. So 1973, they were trying to bring black mine workers into operation. But unfortunately, this never happened. It never happened because all mine workers from all over the country, including those from neighboring countries of Lesotho, Mozambique, Botswana, and Swaziland, as well as Malawi and Zambia, they all had to come to Braamfontein for their medical assessment after they've long retired from the mines. This was so because, as you know, silicosis usually affect mine workers more than 20 years after exposure to silica dust. So many of them will have retired. Now coming to Braamfontein was just an impossibility. So it was almost impossible for any ex-black mine worker in South Africa and in the neighboring countries to access this service in Braamfontein, and hence the compensation mechanism could not function. It was actually in the ICU. Our first breakthrough came in 2014 with the appointment of the new commissioner, but also when the Chamber of Mines, the 5 trade unions which I've already mentioned, and the Department of Health, Department of Mineral Resources, and Department of Labor, when they come together to start a journey to resuscitate the ailing state compensation mechanism. This coming together and cooperation of the parties led to substantive gains in the enhancement of governance and the management of the compensation funds. There is hence improved compensation claims payment and decentralization of medical services to current and ex-mine workers. The decentralization of services away from Braamfontein happened in the form of what we call one-stop service centers, strategically placed in the labor sending areas. The first one was strategically placed in Mthatha and was opened by Deputy President Kgalema Motlanthe, himself a former mine worker, as you know. That was in April 2014. The second one opened in Carltonville, here in Johannesburg, also in April 2014. The third in Beresford in Limpopo in October 2017, and the last one in Kuruman in the Northern Cape in December 2017. Those who follow the history of the country will understand why Mthatha, why Kuruman, why Carltonville, and why Beresford. The one-stop service centers perform medical examination for workers. That's number one. It also rehabilitates those who are ill. That's number two. But it also helps to fill compensation forms for those who are affected, because many of them don't even have a clue or when they must start claiming compensation, what form is wanted, what information. Those who don't have a clue don't even know where that information is obtained from. And the one-stop centers help them to do that. By 2014, before we started this process, but before saying that, let me say the second breakthrough to us happened in 2015 when the mining houses came to see us and we started the journey together. The state, the mining houses, and the trade unions, and the Chamber of Mines. That was the second breakthrough. Before we made this breakthrough, 5 years ago, the compensation commissioner used to compensate only 2,000 mine workers per annum from both South Africa and the neighboring countries. But because of this breakthrough and the gains that have been made, when it started bearing fruit, between April 2017 and March 2018, we were able to compensate 10,409 claimants. They were paid 254 million rand, which represented an increase of approximately 500,000 in claimants and 200,000 in the monies paid. About 110 million went to our neighboring countries. Now, this month of March only, the month of March which has just passed, we were able to compensate 1,203 claimants to the tune of 8.2 million. So if you compare that, only 5 years ago, we're compensating 2,000 people per annum, and we are now able to compensate 1,200 per month. You can realize the steps that have been undertaken. It's phenomenal improvement for us. We also did not put the one-stop centers only in South Africa. We regarded ourselves as the government of South Africa, where most of the mines are, but also the mining houses joined us to regard ourselves as responsible for our neighboring countries. So the one-stop centers were not only the 4 in South Africa, 2 were placed in Lesotho, 2 in Mozambique, 2 in Swaziland, and 1 in Botswana, and all of them were funded by the mining houses in South Africa. This new process allows us to trace ex-mine workers even to the neighboring states. Today, the compensation mechanism is up and running because of the solid partnership between the state, the unions, and the mining companies. We are not just waiting for compensation. As I'm speaking to you today, we also want to see what can be done together to stop mine workers from acquiring this disease, not just to wait for them to acquire the disease and compensate. And for that reason, the Department of Health has hired 9 health inspectors to monitor for screening of silicosis and TB in the mines. And I can assure you, the 9 inspectors, since they started their work, 90% of mine workers, 500,000 mine workers in South Africa, in our mines, are screened for TB and silicosis at least once per annum. We also hired 3 finance inspectors to check whether mining houses are paying their levies to the compensation commissioner. The compensation commissioner for occupational disease in health, the money with which you are compensating, the amounts I was mentioning here, it's not money from the state. The state job is to see which mine worker should be compensated. The money must be paid by the mining houses themselves in the form of a levy. And they're only able to pay that levy if inspectors go to their mines and inspect and tell them how much to pay. And that process is up and running. It has been moribund for some time. Government did not participate in the past class action settlements in covering asbestosis exposure in 2002 and silicosis in 2015. This settlement agreement process today is unique, wherein government was involved through the close links with the CCOD and the MBOD. The alignment to the certification process, the reliance of the parties on the unique database of the CCOD, and of significance is the inclusion of a government representative in the settlement fund, which you are going to be told about. Litigation is an expensive and time-consuming process, and we are going to hear from the lawyers representing from the claimants. I hope that the mining companies covering other commodities and occupational land diseases will follow the tenets of and the spirit of this agreement that has been signed today, so that we don't do a shootout in the court of law. Yes, because the settlement has happened in a way that impresses us. We will try to advise other people who are involved in litigation to try and follow this, which we regard as a very good example. Lastly, I want to state categorically that the cooperation between the 7 mining companies that are going to be mentioned here, the 6th and the 7th has just come in. The cooperation between them, the Department of Health, the Department of Mineral Resources, the Department of Labor, the Chamber of Mines, NUM, NUMSA, AMCU, UASA, and Solidarity. That cooperation, I can tell you, it beats any toy or any street blocking or any burning of buildings, which you could ever embark upon. Because today, we now have a database where we can go to any part of the country or any of our neighboring states, open the database, and read out the names of all the ex-mine workers, some of whom have left the mines, as I said, from 1965. We can do that now, and that was the result of this cooperation. Thank you very much.
Thanks very much, Minister. Graham, can I hand over to you for some brief comments?
Thank you. Ladies and gents, thank you very much. I speak on behalf of the Occupational Lung Disease Group, and it has representatives of 6 different companies: African Rainbow Minerals, Anglo-American South Africa, Anglo Gold Ashanti, Harmony Goldfields, and Sibanye Stillwater. So in about 4 years ago, those companies got together and looked at the possibility of looking at solutions to occupational lung disease. It went on the back of a lot of work that was done on dust and dust control in the mining companies. And as you know, not all these companies are now involved in gold mining, but the majority are. And so we had a presentation to the CEOs of those companies, and the CEOs basically supported the resolution to actually look at a sustainable solution to that. And that led on to the meeting which the Minister was referring to, where we met with the Minister and talked about solutions of occupational lung disease. So I guess it was a challenge right in those early stages, getting 6 companies to agree to something. You can imagine 6 companies, each with their own strategies, their own groups of lawyers, etc. But it was a fairly dynamic session, and I thank the CEOs for supporting that. So in our efforts to eliminate silicosis completely, a lot of work has gone into dust control. However, that's not the subject of today. Today's subject is on the settlement. This settlement, of course, has been several years in the coming, and I guess my thanks must go to all of the various participants that the Minister has mentioned, but especially the claimants, lawyers, and the various ex-mining groups that we've had conversations with, including all the unions, which we've tried to keep in the loop at all times in these discussions. It might be asked that why go for a settlement in a class action like this? Well, I think in any legal process, there's uncertainty. In getting to a settlement, there's certainty. And that's what the mining companies wanted, and I think that's what all parties agreed to in this process. A settlement is certainly preferable from various parties because it brings certainty and it brings the solution, which is payments, top-up payments, if you like, on compensation immediately and sooner than any class action and litigation would do. So eligible claimants will get their payments sooner. It's in the shareholders' interest, of course, as well, because there's now certainty on what this means for the different companies. So something that's good for shareholders, something that's good for the claimants, it's positive for the country, and certainly you've heard the Minister say the positive issues around working together and collaboration on quite a diversified group of people. So I'll be glad to take any questions that you may have directed at the sort of mining companies and the occupational working group after the talk.
Thanks.
Thank you.
Thanks very much, Graham. Richard, can I call on you?
Thank you. The purpose of this litigation, when we embarked on it in 2005, was twofold. First, to hold the gold mining industry accountable for the enormous harm that has been done to workers and their families and their communities who've borne the burden of occupational lung disease that has crippled and maimed tens of thousands these last 100 years without any consequence at all. The second objective was to bring some measure of redress to these miners, their families, and their communities. This has been enormously large and complex litigation. It spans 50 years, perhaps 100 different mines, 32 mining companies, and it relates to tens of thousands of claimants. But that scale and complexity was not the biggest challenge. It's a huge responsibility to represent the interests of thousands of individuals, most of whom are impoverished, many of whom are ill, vast majority hailing from remote rural areas, Mozambique, Lesotho Islands, Eastern Cape, Botswana. People who don't have the benefit of resources, means to communicate and to engage, And representing them as a lawyer is an enormous responsibility. You take decisions that are going to affect the lives of these people. At all times, we've been under pressure from two sides. On the one hand, our clients who are largely elderly and unwell, and living in, many of whom are living in abject poverty, are dying and suffering every day. This puts enormous pressure upon us to reach a settlement, to get money to our clients as soon as possible. In the last 5 years, out of the 30,000 odd individual clients that my firm has represented, approximately 5,000 have died. On the other hand, there is the enormous pressure of not compromising the rights and interests of these workers by settling cheap. So on the one hand, there's the pressure to settle quickly. On the other hand, there's the pressure not to compromise the rights. Now, this settlement represents a balance between those interests. It represents a compromise. Now, how do you take that responsibility? How do you do that? Well, in that regard, we've been very, very fortunate that we've engaged and we've worked very closely with a wide range of social partners. So while we can't take instructions from our clients individually, although we do engage with the class representatives, we have had the benefit of talking to organizations and people who are closely involved and in protecting and advancing the rights and interests of ex-workers. We have some of them sitting here today with us. We have the associations, the various associations of former mine workers across the country from Swaziland. We have NGOs who participated in the litigation, Section 27, and brought an independent voice to the whole process. We've engaged with social partners like the Mine Workers Development Agency, who were our partners in Lesotho, and the Ditshwanelo Human Rights Organization in Botswana. We've engaged on an ongoing basis with the trade unions, not all of them, some of them, different parties, different trade unions. And we've also had the good advantage that we've been able to engage quite constructively with government and get their feelings and inputs. And it's only the inputs from that broad group of people that actually gave us the confidence to make this settlement and to achieve the balance that we have achieved, and makes us confident that that balance is fair, it's in the interest of the workers, it's the best that we could reasonably achieve in the circumstances, in all the circumstances that we find ourselves. It is very gratifying, in fact, to find the very high levels of buy-in from our social partners and other stakeholders, and a lot of support for the terms of the settlement. That gives us the comfort that we need to sleep at night, knowing that we haven't sold out, we haven't compromised, we've done the best that we could possibly achieve. There are challenges lying ahead. The first is that this agreement needs to be ratified by the court, which means another notice process. People need to be given the option to participate in the settlement or to opt out. There may well be people who think that their interests are best advanced by litigating their own claims on an individual basis. And people need to be given the opportunity to do that. I speak under correction, but my understanding is the timetable we're looking at for this agreement to be ratified and finalized and to be put into effect is around about September, October, the last quarter really of this year. And that's quite a way away, and that I'm sure is very disappointing for people who've been waiting so long. But the real success of this agreement, those delays aside, the real success of this agreement will depend on its implementation. The life of the trust is about 12 years, and we've got 12 years to pay and to compensate as many people as possible. And while the companies, and as everyone knows, have made a provision and they've made their estimates of the likely cost associated with this and estimated in the range of 5 billion rand, it could be more or it could be less depending on how well this trust does its job. We're satisfied that the trust has the resources it needs to get out there into the labor supplying areas, to find people, to screen them, and to compensate them, and to do that quickly and efficiently and effectively. What also will determine the success of this project is the synergy that we achieve with the Department of Health. As you've heard from the Minister, there's a firm commitment from everybody to work together to maximize the efficiencies of these parallel schemes, to integrate them and to achieve the maximum efficiencies. A huge burden rests on the shoulders of the trustees, who are independent and who have a responsibility to implement this. We are satisfied that the people who have been nominated by the industry, by ourselves, and other trustees will be fit for purpose, will do the job, and we are hoping for the very best, and that the promise that this agreement holds gets realized. Thank you.
Thanks very much. Thanks, Richard. John, I'm going to ask you to come and run through the brief presentation. If anyone wants copies of this presentation, it will be available on the oldcolab.co.za website, or you can simply ask us for copies of it.
Thanks, Charmaine. Yes, I've been asked to, as briefly as possible, take you through the key features of the settlement agreement as an introduction to the questions that you may want to raise with all of us when I'm done. If I can just emphasize firstly what my role is. Although I am a lawyer, my role in all of this has not been as a litigation lawyer, but as a facilitator of the negotiations, moving in the right direction so that we could eventually reach what we have reached today. And what I want to cover with you in the time I have is firstly just the key features of the negotiation. It was a very, very unusual negotiation process, and I just want to emphasize that with you. Then secondly, to emphasize the key features of the agreement. It is a unique agreement. It differs from some of the other agreements like the Asbestosis Trust agreement. And just emphasize with you what are the next steps. Some of those have been hinted at already, but just so that you should know what's going to be coming in the future. And then just lastly, see what is the key lesson or lessons, if anything, that we can draw from this, both as a mining industry, but perhaps as a country as a whole. And I think some of you may be wondering, why did it take these people so long to settle the matter when people are dying, as you have heard? The negotiations started, the first meeting that we had with the claimants' lawyers was in December 2014. And we've been involved in very intensive negotiations, literally thousands of hours, hundreds of meetings over the last 3.5 years to reach the agreement that we have. And as you know, the agreement has now been reached. And the reason for that is largely the complexity of the issues, but also the complexity of the negotiation process. And in this slide, I want to just give you a graphic indication of how complex the process has been. If you take the negotiation table here, just on the litigation, you have on the one side of the table 5 legal firms, and those firms have been mentioned already, representing somewhat disparate interests like silicotics, TB sufferers, dependents, and on the other side of the table, 6 companies, very disparately situated in the industry for longer periods of time, and with different philosophies, each of them with their own sets of lawyers, with their own sets of advice. It took me about 18 months of facilitation between those 6 companies to get to a point where there was significant common ground between them. And that was also occasioned by the mandating dynamic behind the table, is that each of those companies has a CEO, has a board, has shareholders to whom they had to respond. So every step of the way involved a complex dynamic. But also what made it very challenging for us is we didn't want this to be a settlement isolated from all the interested stakeholders. And over here, some of the interested stakeholders are firstly non-participating respondent companies. I'll show you just now that not all the companies who have been sued in the class action are parties to the settlement, and we have endeavored over time to try to get them to join. We have obviously needed to communicate with the media, who've been very impatient with us about what is happening, but we've had to try to give as much information as we could. We've wanted to engage with a range of NGOs, and that engagement has been very useful. Obviously, there's the Chamber of Mines that represents all the other commodities, and what we do here impacts on them. And then the litigation attorney firms, each one of these companies was represented by a firm of attorneys, and they had to be kept on board. And then here, for reasons which will become apparent, we needed to engage with SADC states. We're going to have to apply to court for this settlement to be approved, so we've had to engage with the court. We've had to engage with 3 portfolio committees of Parliament: Labour, Health, Mineral and Energy, and of course with the executive. There are 3 ministers involved, primarily Dr. Motsoaledi of Department of Health, but the Department of Mineral and Energy is an interested department, as is the Department of Labour. So it's a very, very complex negotiation, and it's part of the reason why it's taken as long as it has. The other thing that is important to emphasize is that very early on in the process, we realized that it would not be a good idea to settle the class action in isolation. As has already been mentioned, there were severe problems in the MBOD, CCOD, workers who were entitled to compensation. Money that had been paid into the MBOD, CCOD by the companies was not reaching those workers. And obviously, if we could get that money to the workers together with any settlement, that would make sense. But also the compensation legislation in the country is not harmonized, and there's it's necessary to harmonize that. So I can't go into the detail, but we initially hoped that we could have a comprehensive settlement which sorted all of these situations out. Unfortunately, because of time, we decided to give priority to the class action and continue to deal with the legislation and fixing the MBOD, which has largely been fixed, but there's still a lot more work to be done there. So the settlement needs to be seen in that context, and a lot of our meetings have been with other stakeholders. Just to take you through at a very high level, some of the major challenges of the negotiation process. Firstly, the multiplicity of parties and stakeholders. I've already indicated that in the previous slide. The multiplicity and the variety of party and stakeholder interests, the primary ones being silicosis, tuberculosis, dependents, but they're rural people, they're South African people, and so on. So there was a very wide range of interests. There was a multiplicity of negotiation issues. It was not just about money. There's a tremendous infrastructure that's had to be put in place, each minute bit of it having to be agreed to by all the parties. The negotiation issues are enormously complex, not only because this is one of the first class actions, but because they are health issues, etc. The issues are very, very complex, and we've been assisted by a wide range of experts, actuaries, health people, and the like. Then, as I've said, there's an overlap of the negotiations on the litigation, the MBOD, CCOD, and the legislation, and we've had to keep everybody on board with that. The complexity of the mandating dynamic on the company side of the table, as I've already indicated, behind every company is a CEO, a board, and shareholders. And as Richard has indicated, to get a sense that the settlement is acceptable to the tens of thousands of mine workers out there has been very complex. And then the magnitude of the costs involved in the process and the outcomes is enormous. So don't just look at what the sums are in the settlement. What has been invested in this process has been very, very large indeed. And of course, this is against a backdrop of the state of the mining economy, which is not wonderful. And then, as has already been mentioned throughout, we were highly conscious of sick people, dying people, and that we needed to get this job done sooner rather than later. And that has been a mighty challenge. Just to take you through the parties, I think you already know that the 6 companies, I should just reiterate, this was done before Pan-African was not in a position to participate, but we hope we may get them in time. But those are the 6 companies that are parties to the settlement. What is also important, I think, to understand is that there are 2 companies that are not parties to the agreement. They are parties to the class action, but we have not been able yet to get them to be party to the settlement. The consequence of that is that the class action will continue against those companies. That also, I may tell you, has complicated the settlement for legal reasons. Very central to the settlement is the settlement trust, which you may by now know is called the Geometer Trust, which means to make good or correct in Setswana. The purpose of the trust is to track and trace as many eligible claimants as possible in the whole of the SADC region, which is a mighty challenge, and I think Richard has already mentioned that. Then to assist claimants to lodge claims, and I think Dr. Motsoaledi said how difficult it is for people to complete all the paperwork, have banking accounts opened and the like, to provide facilities for benefit medical examinations. And again, the emphasis has been, as not in the past where everybody had to come to Johannesburg, but to roll this out into rural areas so that people can be examined as close to their homes as possible. Very, very important to this settlement, and I really do want to emphasize this, is the coordination with the MBOD, CCOD. Very early on in the negotiations, we realized that it would be foolish to have 2 parallel systems for the settlement trust to be going and tracking and tracing workers to pay them a settlement benefit, and for the MBOD, CCOD, the government, to be doing exactly the same to pay them statutory compensation. And what we've done with very, very fruitful engagement with the MBOD, CCOD, is we've tried to achieve a completely synergized situation where jointly, one way or the other, we will go out together, seek out, find workers, BME them, certify them, deal with all their paperwork, and then have them paid at the same time the statutory compensation that is due to them and the settlement that is due to them. And there's about 4.5 billion rand sitting in the MBOD that needs to be paid to workers, and there's an estimate that the settlement is about 5 billion. So there's potentially 9 billion that can be paid out to workers if the synergy works properly, and I'm confident that it will. The other thing is that they will be responsible, obviously, for paying the benefits to the workers. As far as the settlement trust is concerned, it will be governed by 3 trustees nominated by the companies, 2 nominated by the claimants, 1 consensus trustee, and 1 government trustee. And I think Dr. Motsoaledi mentioned that. Again, this collaboration between workers, companies, and government. And because we couldn't have a trust that was colossal, that represented every stakeholder, we've provided for an advisory committee that will have on it various stakeholders that can advise and liaise with the trustees to make sure that the message of the people is getting through to the administrators. What is also important about the funding of this trust, and we learnt it from some of the previous settlements that there have been, is that we separated right from the beginning 3 completely separate categories of funding. The first one was for administration, and what has been provided is that 845 million rand will be contributed by the companies over the life of the trust solely and exclusively for administration. And that figure was arrived at upon advice from actuaries and experts who've worked out what it'll cost to run the trust for its life and ensure that workers get what they need. And it will not be eroded in any way by lawyers' fees or anything else. That is a fixed sum. There will be a 5 million rand initial setup contribution even before the court sanctions the settlement. In the hope that they do it, we want to start taking steps to get the trust up and running. There will then be a 100 million rand first year contribution, and thereafter the 845 million will be incrementally fed into the trust as that money is required. So that's a completely separate bucket, as we've called it. Then there's what we call a benefits bucket, and there you have 10 classes of beneficiaries. The details are in the press release that's been given to you. One of the things that we've done is, as far as possible, we have aligned those classes with the MBOD, CCOD classes, so that if a worker is certified as Silicosis Class 1 for the purposes of statutory compensation, that worker will also be certified for the purposes of the settlement. The other thing is that the statute only provides, if I'm not mistaken, for 6 classes, but we were persuaded by the claimants' lawyers to provide 4 extra classes that are not covered by the statute. So the settlement actually provides a wider range of claimants with benefits. And perhaps the most important one there is what are called the sub 10%ers, people who have lung impairment of less than 10%, who don't get statutory compensation, but they will get compensation under the settlement. And then tuberculosis, people that also don't get statutory benefits, but get benefits under the trust. There's a fixed tariff, which means that every worker who is certified will get that amount come hell or high water. And I think the point was made by Richard that it may mean that more than 5.5 billion will have to be paid out. It may mean less. But the one thing that is guaranteed is every worker will get the amount which you will see in the printout that you've got. So where this differs from some of the other settlements is there hasn't been a lump sum put into the trust without knowing how many people are going to come forward, which necessitates you giving a lesser payment initially, and then if there's enough money at the end, topping up. Here, every worker will get the tariff no matter what that means in the long term. There's also no cap on it, as I've explained. And the way that's going to be done is 1.2 billion contribution will be paid into the trust. That's what the experts have estimated will be paid out in the first 2 years. And then based on the claims record, more money will be paid into the trust as needed. And so the balance will be incrementally. The other thing that's very important is that all payments have been backed by guarantees. And that was another major challenge that we had, is every company wanted the other companies to have guarantees that if they went down, other companies wouldn't have to step in for them. And of course, the claimants are very concerned that if any one of the mining companies goes under, the payment will be guaranteed. So they're very sophisticated guarantees that back the whole transaction. And then as far as legal fees are concerned, the 3 South African companies will jointly be paid 370 million as a contribution towards their legal fees and disbursements. At face value, that may seem very high to you, but bearing in mind that these companies have been actively involved for the last 14 years, we have satisfied ourselves. When I say we, the companies have satisfied themselves that they believe that this is reasonable. And what's also important is that that is not going to come out of the benefits of the workers. This was only negotiated once settlement had been reached on the benefits and on the admin. Then a negotiation took place on the fees for the claimants' lawyers. The point has already been made, the very, very important alignment between the trust and the MBOD CCOD, and I'm not going to elaborate any further on that. As far as the way forward, we have agreed on a very sophisticated communication strategy. It's a very, very complex agreement, and it's going to need to be explained to potential claimants very carefully. The parties don't want to raise unrealistic expectations, both in relation to amounts or time, and that has been jointly worked on, and it will be rolled out, and we're hoping that we will have a lot of help from other stakeholders here. There will be a preliminary trust set up, even at the risk that the deal is not sanctioned by the court, although we are confident that the court will sanction it. We then have to get court approval, and that is something which we are jointly preparing for now, and we hope to get that before the courts within the next 2 or 3 months. And then, of course, there will be a major rollout over the 12-year period of the trust. For me, there is one key lesson that comes out of this, and Dr. Motsoaledi mentioned it. It's a classic example of what South Africans can achieve if they put down their arms and they sit down around a table in a patient and painstaking way and agree on what are the underlying facts, agree on the problems, jointly search for solutions, and engage with one another in a dignified and respectful way. You can achieve these kind of outcomes. And I think it's, again, a lesson for the country of what can be done. And it's a lesson, quite honestly, to the rest of the world. As people have said, and some of the international lawyers who've been advising us rate this as one of the most complex class action settlements in the world, largely because unlike other class actions where you have one respondent, here we have 6 companies with all of the complexity I've shown you. So let's hope that the spirit that has been shown in reaching this deal can be the spirit that is shown in implementing the deal. Thanks.
Super. Thanks, John. Okay, we would be very happy to take your questions from the room and then also from the webcast. Ed Stoddard?
Thanks. Ed Stoddard with
Ed, could you hold on 1 second? The mic is on its way.
Thank you very much. Ed Stoddard with Reuters. I was just wondering if I can ask a bit of clarification on this. So the companies have provided 5 billion rand, and that's just for claimants. So the 845 million rand for the administration of the trust, and the 370 million rand to go to the law companies that were representing the claimants. Is that something extra on top of that, and will that be something that the companies will be providing? I'm sorry, I'm just a bit unclear on that.
John,
point.
could you respond?
And I just have another question on top of that. So Richard, if I understood you right, over the 12 years, is it possible that if you don't find everybody that you think is deserving or is entitled to a claim, that there could be, that not all the 5 billion rand might be paid out? And is it possible that more could be, and that the companies may have to pay out more than the 5 billion rand they've made provision for?
Right.
Thanks.
Thank you. John, will you answer the first question?
Yeah, my understanding, and I speak subject to correction from the lawyers involved, that the 5.2 billion is a rough estimate of the total expenditure over the period. It would include the 800 and whatever million for admin and for lawyers' costs.
Okay.
Right. And Richard, would you be able to open? Oh, sorry, John. Graham, you want to?
Just turn those numbers around a little bit, please. So there's 3 buckets. The one bucket is fixed, and that's the admin.
Okay, and that's it.
The other bucket is fixed, and that's the lawyers' fees. The last bucket is flexible, which is what John was saying. There are amounts specified in the press release you've got, and the amount, obviously, that has to be paid out, the total sum in the end, is subject to the numbers of people that come forward in those different categories. So that's not a fixed amount. Could be higher, could be lower, but it's at the moment a best estimate. But those numbers in the agreement, as you see them, are the fixed numbers.
Okay, so the number could go up.
What number?
The number in the third bucket.
The third bucket number could go up, yes.
Or it could fall short of that, right? It could do either.
Yes.
Yes.
It's based on claimants coming forward and based on the work that the trust has to do with the government on tracking, tracing, finding these people.
Right. Richard, did you want to add to that, or are you comfortable?
No, I just want to make one point, perhaps. At the end of this 12-year period, the status quo reverts. So we hope at the end of this period there are no new cases and there are no new claimants. Otherwise, this process will be repeated. However, there is also the prospect, what we are considering is legislative changes and reforms, because if we had adequate statutory compensation schemes, of course, this entire litigation wouldn't have been necessary. So there's going to be legislative reform, and I'm pretty confident that at the end of this 12 years, this problem should largely have been addressed.
Thank you. For the question, Alan?
Hi, Alan Sekema, Business Day. Speaking to various participants in this over the past few years, I find it difficult to understand why you don't have a fixed number of how many claimants there might be. I've heard numbers ranging from 30 to 100,000. Is there no way to have nailed that down in the past 3 years of negotiations? Surely there are enough experts out there.
Who would like to answer? Yeah. Charles Heward, would you like to come stand here?
Charles Abrams, one of the claimants in lawyers. You're absolutely right. And if you look at, the numbers out there from research papers, it's, staggering numbers, from, 1 million to 1.2 million. But that includes the entirety of the gold mining industry, mine workers, who ever left, the gold mines. And, that includes, all other disciplines, as well. And that's not what we're really talking about. What we're talking about are those, specific to the class action. And they would be miners, falling within the, the ambit of those with silicosis and, of course, those with, tuberculosis. And again, even those within tuberculosis is somewhat, narrow. Now, from the work that we have done, there is no research, on this. And it is an area that I think, certainly, needs that. We have worked, together, on this, together with the industry, together with government, with MBOT, and our own research, in trying to come up, with, best, guesstimates, but they still remain, guesstimates. Some would say, and I don't think that, we can rely on, these figures, that, we, perhaps look at, the upper limit of 100,000. But I think that, if one looks at, the way in which the settlement is structured, it will, provide, each and every claimant, eligible claimant who's eligible, it will compensate, that claimant. So if it is, 100,000, it is 100,000. If it is 50,000, it is 50,000. So I think that that is what we need to focus on, and perhaps, out of this, we will, be able to get, a better number. The key focus is here is that it is an open-ended trust, and, the companies, have undertaken, to honor each and every, through the trust, claimant, provided that they are eligible.
The numbers from MBOT and CRID, let me give you a few of the numbers.
Well, these are guidelines, but you must remember that, as the minister indicated, that there's been institutional problems within the MBOT, and so we all have these challenges. We have also roped in actuaries, and even they themselves, if we look at numbers, we're falling back on the very deficient numbers that we have. So what the trust is seeking to do is to say that, look, given that we instead of having a fixed number, an amount that we've agreed upon, we are prepared to honor each and every claim that comes to the trust. And as Richard has indicated, it very much depends on how the trust undertakes its work, and the more claimants come and they're eligible, of course, the better for the trust.
Well, can I also come in?
Okay, Minister, would you like to
Yes.
respond?
Yes, I think the question assumes that mine workers in South Africa were like all other industries, where they are well recorded, we know where they come from, we know their addresses. If you know the history of mining in South Africa, you'll realize that there was nothing like that. Even after we started this process, when we identified 105,000 mine workers in 2015, which qualify, we had 3 billion rand for them. It was a big struggle just to find them, because this money is not going for anybody who is a mine worker. It's going for anybody who was a mine worker who have been afflicted by either silicosis or TB. They've got to prove it. That's why in my speech here I said, in the beginning, part of the reason why there was a problem, they all had to voluntarily come to Braamfontein, regardless. In other words, the mine worker had to have a consciousness, personally, that I was working in the mines, I'm now retired, I might get sick, let me go to Braamfontein for a checkup. It was not just happening. So we have established the Department of Health, together with the mining houses, established these one-stop centers. As I said, one in Mthatha, that's where most of the ex-mine workers in South Africa are from, in Carltonville, where most of the gold mines are, in Bakersford, where there are lots of gold mine workers now, and then in Kuruman. Now, I said those one-stop houses, firstly, has got facilities to examine. You have got to examine the mine worker physically to see if they've actually got this disease. That's number one. Number two, we then rehabilitate them. Number three, you help them to get their records, and they are very difficult to come by, because many of them, to tell you the truth, cannot even remember the name of the mine where they worked. They just know that I was in a mine somewhere in the 60s, and it ends there. And we have got to go and search. That's why we brought TEBA. If you remember, there was an institution called TEBA. By the way, I know TEBA, but from the 60s. The Employment Bureau of Africa. That is the structure that even has got bad. And it was a bureau for mobilizing mine workers from the far rural areas. That is the only one that has got nearest to the records of mine workers. So it's as difficult as that. In other words, even with the money available, you struggle to find them. Secondly, you are not easily going to find, for those who passed on, the widows will be paid or their next of kin. It's not going to be very easy to find them. The Dr. Barry Kisnasang, where is he? Yes. Has paid a lot of visits. Come, why are you sitting at the back? You're the main guy also. He has paid a lot of visits to Botswana, to Mozambique, to Lesotho. We've even mobilized the ministers of health, of labor, of mining in those countries to help us to search for these people. And it's extremely difficult. So it was going to be difficult to say, we have got money here and it's for so many people. I think we can just estimate that so many people will come. And that's why they say the 5 billion will go either up or down. And very unfortunately, from the experience I've had from the Compensation Commissioner, from the CCOD, it might actually go down because you might not find them. Very unfortunately, despite the fact that the money is already there. I told you the first tranche from the CCOD, away from the class action, was 3 billion. We're struggling to distribute it. Now there is 4 billion. We're still struggling to distribute it, apart from this 5 billion from class action. So it's not a very easy thing. And the fact that the mining houses asked us to develop a database electronically has actually helped. Dr. Kisnesheim was faced with 800,000 files from 1960, which he has to go through. And because of this digitalization, after going through about 250,000 files, we discovered that 105,000 need to be compensated by 2015. We could not even find them. So the 800,000 files of ex-mine workers are still there. And you might not find the human being, but the files are there.
Thank you. Richard?
Can I just say something about the estimates of the costs and the money that's available to be distributed? Look, it's not a number that was sucked out of our thumbs. Both the industry and ourselves employed actuaries to look at the epidemiological data that there is and to do calculations, and quite detailed calculations of what we anticipate paying out. There is problems with the research. Epidemiology in this field is a bit sparse and scanty, but the actuaries can work with it. The amount of 5.2 billion rand is the company's provision. Now they've made, these are listed companies, they've made a provision. A provision is a liability. It's not something you do readily. You do it on the basis of your reasonable confidence that you can do it. Our numbers differ slightly from the industry. We think there are more claimants, and we think the numbers will be higher than what they anticipate. Our calculations include what we imagine will be the uptake. So we look at different scenarios about how efficient this process will be of identifying people, what percentage we reasonably anticipate we're going to find. And at the end of the day, while we differ slightly with the industry, we think it's in the ballpark, and we think it's a fair reflection of what this trust should do if it performs its job adequately and according to our expectations. So it's definitely not a thumb suck. We're fairly confident that this is more or less the range. If we do well, and we'll do better than that.
Right. John, do you want to add?
Yeah, just one of the spin-offs of this process is there's been a tremendous amount of pooling of information. So the parties haven't been working on their own information without sharing it. So there's been a lot of sharing of information, and there's the development at the moment of a very sophisticated database, which also links into pension people and so on. So the point I want to make is that we have tried to tap into everybody who has information, pool it, and draw learnings from that.
Can we go to a couple of others for the moment? Lady at the back over there, and then Angela.
It's Mpo from ENCA. Just for further clarification, because I read somewhere that Richard was representing about 20 or so claimants. So do we have at least a figure of how many claimants we had in the suit? And also, I'm not sure, I probably missed it when my colleague was asking it. So the 5 billion rands, it includes also the lawyers' fees and the administration, or is it separate from that?
Okay.
Thank you.
So Richard, would you like to answer the first one
Yeah,
for your 20?
I'm not sure where the number of 20 comes from. We've got about 20 surviving class representatives. We started, I think, with 30, but we represent about 30,000 individuals, mainly from the Eastern Cape, Lesotho and Botswana, and the Free State.
And Graham, would you mind just doing a reminder?
Let me try and do this differently because we're battling to get across. So the companies have looked at the actuaries' information, which is a pooling of various information, whether it be the MBOD, whether it be different companies looking on history. And they've calculated what the potential cost of that is. And that's the 5 billion rand. But if you look at the actual progression of these payments, there are 3 buckets. The first 2 buckets, which is the administration. Now that's a big number, but remember that administration includes tracking and tracing, medicals, etc. So that's part of it. So that's the biggest part of it. It includes lawyers' fees. And then the third bucket is the actual physical amounts that are paid out. Now those physical amounts, by negotiation and agreement, are fixed and they're in the press release for the various classes of payments. If there are more claimants than the actuaries have estimated, then that 5 billion number will increase. If there are less, then it will decrease. But the actuaries have given us the best estimate of it, and that's what the 5 billion is.
Thank you. Angelo?
Hi, this is Angelo Coppola from China Global Television. Just on a point of clarity then, is this a once full and final settlement figure per claimant that we're talking about in those 10 classes? And secondly, who's liable for the ongoing health expenses that these claimants will obviously be having to fork out?
Who's going to answer that?
Richard.
So this has been a difficult part of the process. The Odumwa fund that the minister talks to and that I run at the moment is an income protection fund. To date, in terms of the law, the administration, the costs of healthcare, if you're not a current mine worker, so if you're a current mine worker, then the industry, the mining company will cover your costs, oxygen or the benefit medical examination. Once you become an ex-mine worker, the costs accrue to the state. So I get special funds through Minister Motsoaledi's budget vote that funds the cost of the medical examinations and the cost of healthcare. And invariably, people will land up probably in the state sector for that, whether it's in South Africa or in neighboring countries. That's part of the revisions we want to do to the law going forward, that the new levy, because this fund will operate for about another 30 years, should cover the costs of healthcare, the costs of administration, and the cost of the medical examination. So that's about the law as it stands in terms of that process. And that's a flaw in the law. Income protection laws by themselves, or medical aids, or pension funds, the levy covers the cost of everything. And this was a flaw where what we call externalization took place. So except for the income protection part, the rest of it had to be covered by the state. Now, in terms of the settlement fund, as my understanding is that this is a supplement on the income protection part. There is a special category that was put aside for what's called hardships and things. It's on a special category. It's a special class that where the income protection kicks in, but where a panel of medical doctors can say that there's a special hardship built into it, and I stand corrected because I haven't been close to the last drafts, that on the motivation of the medical panel, which will say that for pain and suffering and some, cancer, and we need to do certain things, then there'll be an additional money set aside. But I just stand corrected on whether that's in the last draft. Because we had made inputs to the process, but I'm not close to the process in terms of that process. But the point is that this is a fundamental flaw in terms of the healthcare costs, etc. And particularly, these are non-curable conditions other than TB. And therefore, oxygen is a very important issue that helps with improving the quality of life. And those are discussions we are having outside of this room but not part of the settlement process.
Richard or Michael, would you be able to just give the clarity that is needed there?
I can just talk something about the quantum, and in particular in relation to the silicosis people. So again, these the classes are quite different. The class that was got our closest attention was the silicosis class. Mm-hmm. The quantum that we've determined for silicosis are based on an assessment of their common law claims. Bear in mind that most of these people are old, they're unemployed, so loss of earnings and kind of duration of lifetime is fairly limited, which impacts on the quantum. We've looked at what they might get if these were individual claims for damages for a typical worker in the situation with this condition. And then we've discounted that. And we've discounted that for the risk of losing, we've discounted legal fees, we've discounted the benefits of a quick administrative payment. And through that discounting process, we've arrived at these numbers. So we think that these numbers can be justified by reference to common law claims, considering a whole range of circumstances and fitting the typical worker. There is another category of people, particularly the dependence claims, the claims of the widows, where in practice it is very unlikely that many widows would get a claim, because they would need to prove the cause of death. To get a dependence claim, you need to prove that the dependent died as a result of this disease. Now, without medical records and a post-mortem report, that is a virtually impossible task, except for people who have access to sophisticated medical services in their last days, which is the exception. So in those instances, what we've done is agreed to make it easier for widows to claim compensation and to claim benefits. So we're not requiring widows, in the vast majority of circumstances, to prove that their husbands died of these diseases. We simply need to show that they had these diseases, and then we will pay a widow a benefit. Now, because we're paying that, again, because we're giving something here that we would otherwise not have to give, we've increased the pool of people. The benefits are reduced accordingly to represent that. So there's a bit of a social engineering exercise going on here, broadening the pool, making it easier to win, but there's a compromise in terms of the quantum. So, but we are comfortable that we can justify the quantum back to, we can defend these on the basis of common law principles relating to the damages and generally the way you calculate them.
Thank you. Charlotte, were you still looking for a question?
Hello, it's Charlotte Matthews from Mining MX. Could you talk about any other class actions against mining companies that might be pending? I presume perhaps if there were changes to the legislation, that won't be necessary, or is it necessary for people to bring class actions for previously incurred diseases?
Must I answer that?
Yes, please,
Yeah.
Richard.
Asbestos has largely been dealt with. Silicosis and tuberculosis in the gold mining industry has been dealt with. Our attention is now focused on coal. There is litigation against Sasol. We're preparing litigation against Exaro and other coal mining companies. We have a social partnership with the Catholic Church, and they are our social partner, and together we are bringing this. At the moment, the intention is not to bring them as class actions, but as group actions against individual coal mining companies.
Thank you. Janet, you wanted to make a comment?
Yes, well, the first comment really is in relation to issues of the medical costs. I mean, I think if you look at the classes, you'll see class 4 is a class which specifically addresses complex medical issues that are then covered in relation to the class, and clearly that's one of the things that the trust would have to deal with. So I think that the idea that people who are having ongoing and very complex medical issues to deal with, I think that is covered by virtue of that class. And, you know, with regard to future actions, I think the idea that we have been trying to put forward very strongly in this process is not only that the compensation legislation needs to be tightened up, but rather that the whole framework, which doesn't land up in compensation but lands up in prevention, needs to be tightened up. And that's something that, if it doesn't happen, there could be other industries, other sectors other than the coal one, that would obviously then land in the same problem, which we hope does not happen. And I think that that's what the Minister alluded to.
Okay. Any further questions over here? We take one question over here and one over there, and then we've got a couple of minutes where we're just going to get feedback from civil society organizations.
Naledi Matlapeng from SABC TV. I just wanted to find out how many companies were you targeting before the settlement, and then what happens to these companies? Are they just off their hook? Do they have to take responsibility? Are you going to pursue them one way or the other? And then I also want to find out what happens 12 years down the line if you're not able to actually trace some of these people. What is going to happen to that money?
Right. Richard or Charles or Janet, do you want to answer the first one?
So first of all, I think that the idea that any of the companies, I think at the beginning there were 39, am I correct? 39? 32, I beg your pardon, that were cited in the action. I think that there are aspects of the responsibilities and liabilities of those 32 that have been incorporated into the agreement. And to be frank, the 6 companies that are on board in this agreement have taken responsibility, many of them, that go beyond their kind of very strictly defined legal obligations, and I think that is truly commendable. Hopefully that's going to be the consistent trend. But I think more importantly, as I believe Richard said, that it may have been John, that there are companies that are not in that loop, and so the class action against them will have to continue.
Let's go for a shootout.
And Graham?
Can I just clarify the numbers, because this is where we could get confused. The 32 companies that are referred to in the documentation represent now existing 9 different companies. So there's been companies that have taken over, or collectively they've restructured in such a way that those 32 companies actually represent 9 companies. 6 of those companies is the working group, and the other 3 companies, one of which we've talked about briefly, which is Pan-African, and there's 2 other companies which represent a relatively minor proportion, somewhere probably between 10 and 15% of potential claimants.
Thank you. Sorry. Yes, Barry?
Yeah. So remember the presentation by John Brand talked about the 2 systems that are going to work closely together. The statutory system, or DIMWA, and the settlement fund. Now, the statutory system is still going to continue for some time to come, notwithstanding what Richard calls the window period of this 10 years. In fact, sooner we should try and get the integrated one system. It's awkward for mine workers to say they've got to come to Minister Motsoaledi for heart and lungs and go to Minister Oliphant for heads and legs, because that's how the 2 systems work at the moment. If you have an injury for your head and your leg, you go to Quida or Rand Mutual. And for heart and lungs, we've got to come to Minister Motsoaledi. So that's why everybody's pushing for that, and there's political will to deliver on that agenda. Now, the key issue is that what happens after 10 years, we are hoping that with the rapidity of the discussions we've had to date and the investments made by the mining companies, they've put in the region of about 150 million over the last 3 years into the MBOD CCOD apparatus, which has realized many of the gains that Minister Motsoaledi talked about. So we're hoping that that throughput will help with this initial wave of from 1965 until when the court makes the settlement, because that's the class action. It's a period that covers it. Remember that statutory system under ODIMWA will continue, notwithstanding the model. So the model, there is discussion at the moment, subject to further discussions, that new workers joining the industry as of a certain date of legislative change will go under Quida. So that means new workers, a novice worker, 18-year-old, 20-year-old, never been in the mining industry before, starts off under Quida. Of course, there needs to be reforms to Quida as well, but that's a different ministry, and we will make inputs to that. But the current workers, and I don't want to get into a very bedeviling issue called control mines, but let's leave it at that. The current mine workers and the legacy problem, ex-mine workers, are covered under the Odumwa Fund, which will then phase out over the next 30 years. And the Odumwa Fund, subject to one or two machinations that will change, like the levy, the 4 classes, so we're going to make some changes that will allow for the 0 to 10% category, what's mild silicosis, the first degree and second degree, and then the special cases. And that realignment, because we think there's sufficient statutory reserves in this fund of 4 billion to cover those things, that will continue. So post the 10 years, or 12 years of the trust, which covers this class action grouping, there's still a fund that the companies are still continuing to pay for that will, over the next 30 years or so, as people die out under this fund, then will still be covered in terms of that statutory benefit in terms of the process. And we're also wrapping it up in terms of its equalization, inflation-linked benefits, et cetera, et cetera. So I hope that helps you in terms of that process. Of course, the question could be, could the settlement fund be open-ended? And I'm sure the lawyers have decided that it can't be an open-ended fund because you've got the statutory benefit. This is just a top-up for the initial part, and then you deal with the legacy, and then you start moving forward on a semi-perfect scheme that should have worked historically. As Minister pointed out, the scheme collapsed 40 years ago. If the scheme had not collapsed 40 years ago, I promise you we would not be facing litigation today.
John, can you just add to that?
Two minor points about the 12-year period. The one is that the expectation is that all potential claimants will be found in that period, number one. But the other very important point is there's been a dramatic decline in the incidence of silicosis because of the great improvement in dust control. So the expectation is that there will be very few new workers becoming ill with silicosis. That's the advice of the experts.
Graham?
Thanks. Just to add to John's point, since 2008, there hasn't been a recorded silicosis sufferer that was a novice to the industry. There may well have been silicosis identified in people that were not novices or had been in the industry prior to 2008. Now that's a 10-year period. I think if you speak to the professionals like Barry, then he would say there could be up to a 20-year period. So it's a good indication. It's not absolute though.
Thank you. There was a question. Sorry, Minister?
Yes, I think suffice it to say the complexity was formed, as I said at the beginning of my speech, that the state had 2 compensation mechanisms, which confused even us in the state. I've got to remind myself time and again that ODMWA, Occupational Diseases in Mines and Works Act, in health, compensate for lungs and heart disease only in the mine, if you get it only in the mine. Then COIDA, the compensation of occupational diseases and injuries under the Department of Labor, compensate for anything including heart and lungs in other industries. So it's a little bit confusing and complex. And so we need new legislation to do away with this complexity, to make it very simple. But also the fact that COIDA in labor was always compensating better than ODMWA in health, and that's historical. So at the present moment, it means the complexity will go on for that period because ODMWA or CCOD will continue. Even these people who are going to be compensated by class action, they'll still be paid from ODMWA. That's why some will get double payment. That's why they are saying potentially they will share 9 billion, not 5 billion. Because the 5 billion is for the settlement, but there is 4 billion already from the statutory compensation from the Compensation Commission of Occupational Diseases. So whether you got money from the class action, it doesn't mean we can't give you the other money from statutory. It will go on, right? So that is the second complexity there. Then the third one is that because we want to phase Otmoa out, any new person who enters the labor field will go to COEDA automatically. But then there will those who will be left under Otmoa, and they'll keep on coming. And I can't predict that future class actions from whoever, maybe from a different group of lawyers, from whoever, I can't predict that it won't come. This settlement is just for the present group of claimants with their lawyers, with the mining houses. We don't know what will happen to the future because it does not preclude and close anything. Somebody was asking whether it's closure and once and for all. We can't say that because we don't know who might appear and say, I was not happy with that settlement. I want to go and do a shootout in court, and this is what I want. They'll still be allowed to do that.
Thank you. We have a question over here.
Oh, thank you. Okay. Thank you very much, Minister. In fact, I think the first part of my question has already been answered.
Can I see you so that I hear you well? Oh, okay.
Yes. I was saying the first part of my question has already been addressed. I think the last point on, because I was going to ask on the parallel processes, one from the class action and then also from the ODEMA, but I think that has already been addressed. And I think now
double rather than parallel.
Yes, well, double, yes. Thank you very much for that. And the last question really was on the current project. There's currently the TB in the mining sector project, which is the one that Dr. Berry mentioned earlier, on the occupational health centers that have been set up in Botswana and all the different labor-sending countries. So my question is, how does that project fit into this current process?
Thank you. Barry, should we give you the mic?
No. Yeah, let me answer it. The one-stop centers which have been established is specifically to pick up the ex-mine workers and who get sick, who are out there in the former Transkei. That's why we put it in Mthatha, in Beckersford, in Kuruman. You'll understand why Kuruman, as I said earlier. That's where most of the asbestos sufferers have been. And then also here in Carletonville. But on the issue of fighting TB, that's another process in which we called all ministers of health. I think, when was it, 2013? Yes, for the World TB Day, to talk about TB in the mines, because it's a growing problem around the world. What we are doing here is historical. The fact remains that TB has been found 200 years ago. We had believed around the whole world that is a disease that has been defeated. We are waking up to realize that we're wrong. Scientists, politicians, society at large were wrong. TB is growing. In fact, by 2014, TB overtook HIV as the biggest killer of all the infectious diseases in the world. We are now standing at 1.5 million people who die of TB annually. And that's why this year, by the way, I also know these figures because I'm not knowing them only as a Minister of Health in South Africa. I chair the Global Stop TB Partnership. It's a United Nations institution which has been set up in 2005 to fight TB around the world. I'm the current chairperson. And through that seed, we motivated in 2016 that TB is undermined. It's the only major epidemic that was never debated at the United Nations. HIV/AIDS has been, malaria has been, Ebola has been, TB no. And so for the first time in history, in September, heads of states are invited to United Nations to come and debate TB because they said the scourge is going beyond the powers of the ministers of health. It's affecting development. So we are putting mechanism to fight it. So within SADC, what did we do? The World Bank joined us and they contributed money, Barry, isn't it? The Global Fund to fight TB, malaria, and HIV/AIDS joined us. The DFID, Department for International Development in Britain, joined us. The International Office on Migration, yes, IOM, they also joined us. And what is the aim? The aim is that we need three things from this partnership, from money from the World Bank, Global Fund, etc. Number one, we need a database of all the people who suffer TB within SADC, whether they worked in the mines or not. The mines add an additional flavor because why? TB is prevalent in 3 areas within communities. Number 1 is correctional services. It's even more than the mines. Number 2 are the mines. Number 3 are the peri-mining communities. Communities that stay around mines, they've never worked in the mine, but they stay around there and they get affected. So we need to find out all the people who have got TB in SADC, put them on a common database, right? So that all the countries will know them. Secondly, develop common treatment protocols. I'll tell you why. Even up to today, we've got ex-mine workers who move from Swaziland to the mining houses in South Africa to collect their treatment, because some mining houses were treating them. And he gets treatment, then retires and go home in Swaziland, and they believe the pills they get in Swaziland or so are different from the ones they get here or inferior. They travel back here to come and fetch the pills. Or when a mine worker is being treated here, they go to Lesotho and they get to a clinic. The clinic doesn't know anything about them. They don't know how they were treated. They can't remember, they are not educated. They can't even tell you drugs on which they were. They get started on new drugs and it causes complication. So having a common treatment protocol, this is how it's going to work. We are going to give all the TB treatment protocols, color code the drugs. If it's rifampicin, if it is ethambutol, if it's, you know, I'm forgetting them, I haven't been working in the hospital for some time now. If it is INH, they are given colors. All the mine worker, whether it's in Swaziland or in South Africa, etc., all they know is the color. All they have to say is, I'm on a blue envelope. And the code will tell the doctor that blue envelope means this and these drugs. The other one will say, I'm on a green envelope, and the doctors will know whether they are in Swaziland or in South Africa or in Mozambique. That is the second one. The third one is the referral criteria. Who must refer to who? If a mine worker is in South Africa and the mining company decides to treat, and now it's time to go back home, who must do that referral? How will the minister in that other country know? Because the Minister of Health in Lesotho, former minister, she's no longer there, I think she's working for Global Fund, used to tell me that, please, there are workers who get dumped at the border and they just come back home, and I'm not giving any history. She said, I'm prepared to treat them, but please, let them be presented to me officially, that this person has been working in the mines in South Africa, he's coming back home, take over, this is the treatment. Now, all those things were not happening. So they are not part of this class action. There are things that we have been doing separately as ministers of health, together with those organizations I've mentioned. I forgot the World Health Organization amongst them. All of them were together in solving this problem. And I'm happy because when I went to the meeting of the ministers of health under the World Health Organization in the Africa region, they said they want to adopt this SADC model. The model I'm talking about is in SADC only. And the rest of the African continent want that model.
Thanks, Minister. I'm going to take one more question here, and then we're going to have our civil society commentary. And then we need to close. Thank you.
Thank you, Madam. Mine will be a little bit, slightly from what we are discussing about. I'm a mine worker. During the time when I started mining in the mid-70s, there were a lot of mine workers who were from Eastern Cape, who came into Lesotho and take the contracts in Lesotho. When we asked them, why are you doing this? They were saying that they were stopped from taking the contracts in their country of origin, meaning that we are likely to have the people in the data of Lesotho who are not of Lesotho. And other ones are the people that are nearby homeland, near Swaziland. I rather forget Gangwan, I think, the Gangwan, who used to go to jump to Swaziland. Other one were the ones from Buputazwana who used to jump to Botswana. I did not know what was happening politically in South Africa that was harassing these people so that they're going to jump the fences and take the contracts in the other area. I'm trying to recall the minds of the people that are going to make the track and traces, that the people that shall not be found in other country are the people that shall be found in another country. This is something that I have got the truth of it. Thank you.
Thank you.
It makes no difference. It makes no difference at all, because the compensation commissioner doesn't differentiate between Lesotho, Botswana in terms of compensation. The class action also won't, as long as we found that mine worker. That's why they've been trips to Botswana, to Lesotho. As long as we found that mine worker, we've got the proof that they worked in a mine in South Africa. Doesn't matter when they left or registered across the border or what, it won't affect them at all.
Thank you. Charles, can I ask you to come up and introduce the civil society commentaries?
Thank you. Just in response to some of the observations and points raised by the minister, it's a known secret in this litigation that throughout the period I've had a particular bias towards the cause of minors with tuberculosis, and when you're within a litigious space, it becomes very, very challenging, because we understand that tuberculosis, the causal nexus between tuberculosis and silicosis is extremely tenuous, and more tenuous from a litigious point of view. This litigation has and the settlement has indicated that both parties have adopted a very pragmatic approach, and I think it is very much also informed by industry and government's work on TB in the mines. And so it is wonderful to hear the ministers placing TB out there in the work that that's happening, and I hope that again that this settlement will further amplify that. But I want to say that we've been speaking as lawyers, we've been speaking as industry representatives and as government representatives. But when we look at the names appearing on the class actions, and there are 69 of them, Mr. Nkale, Mr. Dwadube, and all of them, people with real stories, having worked in the mines. And over almost 14 years, we've had the privilege of working with people underground who had borne the brunt of it. But as lawyers, these are very difficult, it's a very difficult, terrain, in which we've worked. And throughout that process, we've worked with tremendous groups, of people every single day working with these miners. And it's been a tremendous opportunity working with them. We've worked with Section 27, who had, come in and supported, the entire litigation as an amicus, together with TAC and Sonke Justice. And Mark Haywood is going to say just a few words within 2 minutes. We've also worked with Southern Africa Ex-Miners Association, who have chapters in South Africa, the Ex-Miners of South Africa, working with Jubilee South Africa, Lesotho Ex-Miners Workers Association, Swaziland, we have the Ex-Swaziland Mine Workers Association, and then of course in Mozambique, we've been working with AMIMO. These organizations have, provided incredible assistance. And I trust that once this trust is established, that they will continue to engage with, the trust, because they know the situation underground. And we would really like to thank them. And I'm going to call, Mark Haywood and, Varma, I don't know the order, up just to say a few words, of, their involvement and their support, for, the settlement. So maybe Varma, if you could come up, and then maybe Vark.
Good afternoon, colleagues and friends. In fact, as Miners Association, which is the Southern Africa Miners Association, which is represented in 7 countries in SADC, we are actually pleased and we welcome the signed settlement, and we are confident that it will actually go a long way than even what has been written down. And we also want to put into this house that whatever that will be necessary to reach out to those who has been claimants, the Miners Association is the right platform that been registering all of these ex-mine workers in different countries. And again, we strongly believe that this is not a gain for us who are still living, and even not, it also go towards those that has passed on. And it also one way on how to fix the current situation, because mining does not end today, but it still continues. And then I am sure that this settlement has come up with a lot of learnings that we're actually picking up on the ground. And coming to whatever that will take place, as SAMA, we believe that there is nothing for us without us. And whatever that the trust to be established becomes available, we are there to assist. If it comes to tracking and tracing, we are on the ground, we can actually get hold of those people. When people say that they can't find mine workers or beneficiaries, I tend to disagree with them. I think it's just that they haven't found the correct structures that they can work with. If you work with tracers and means registered tracers and others, agencies, those are the people that are there to make a living. But when you talk about the ex-mine workers, you talk about the right organization of the highly affected people, and who knows where the other ex-miners are. Even today, if you make one call to an ex-mine worker, I'm sure that more than 100 ex-mine workers will be aware of that call, because they've got a very strong network. And on top of that, mine workers have survived the life where they can not share with anyone, whoever that person can be, but they better understand the ex-mine workers themselves. So the reason why we are not paying beneficiaries the social security fund, it's because the ex-mine workers themselves as an organization is not taken into consideration. Look at the period when tracking and tracing was done, when the ex-mine workers were not here. Little money was distributed in these communities. But today, even Barry will actually be the witness to say that with the work that we've been doing with him, we are actually making a good impact. We really appreciate the efforts to the mining companies, to our lawyers, and as well to the government of South Africa in supporting this kind of work.
Good afternoon, everybody. My name is Mark Hayward. I speak for Section 27, which is a human rights organization that focuses on the right to health in South Africa. We supported this litigation and represented the Treatment Action Campaign and Sonke Gender Justice in bringing arguments before the High Court that we thought were relevant to the court, particularly on issues around the transmissibility of damages or awards to family members of deceased mine workers, but also to try to draw attention to the impact that silicosis and tuberculosis have had on communities and have had on women in particular in rural communities throughout Southern Africa. I'm here just to welcome this settlement, a historic settlement. It's a day of very good news in many respects. We see it as a great victory for mine workers and for ex-mine workers. We see it as a great victory for South Africa's constitution, a very important victory for public impact lawyering, public interest lawyering, and we would like to thank the 3 legal firms who have persisted with this litigation in the interests of the mine workers over many, many years. And we'd also like to thank the mining industry and the companies for opting eventually for a route of negotiation as opposed to further confrontation and further delay, which ultimately was only going to lead to further loss of life without compensation and without relief. So this is a very, very important step forward. Obviously, today is a milestone, but it is not the end of this process, and that has become clear in the course of this press conference. Many pitfalls lie ahead. There is a tendency for underclaiming on these type of funds from these type of trusts, and therefore the role of the media, the role of organizations such as VAMAS, the Southern African Ex-Mine Workers Association, in making sure that this information and the details of this settlement reaches the furthest corner of Southern Africa, reaches every mine worker who is eligible for these funds. That is the job that lies ahead of us. And as the Treatment Action Campaign and Sonke Gender Justice, we offer everything that we can do to assist the representatives of the applicants and the mines themselves to do this. What I'd like to finish by saying is that in reality, the end of this process will be measured when every eligible mine worker or dependent family member of a mine worker has received compensation for the suffering that they have endured as a consequence of silicosis or tuberculosis. And the end will also only be when mining is conducted safely in Southern Africa without the risk of either silicosis or tuberculosis. So we remain committed to both of those ends. We remain committed with the industry, with the lawyers, with the ex-mine workers associations and the unions to commit to steering the course to a safe mining industry for the future and for proper compensation and relief in the past. So thank you very much and congratulations to you all. Thank you.
Thank you. Do we have any more questions? If not, we'd like to thank you very much for joining us today. There are 2 points that we would like to make to members of the media, and if you could, particularly in your articles and in your broadcasts, make it very clear that mine workers who are obviously going to be impatient, this is going to take a little bit of time, and what they should be doing in the first instance is actually ensuring that they register, get their benefit medical examinations and register with the MBOD. And the second thing that we want to make sure is that they understand that they do not need to pay middlemen to be able to do that. So if you could communicate that, we'd be very grateful. Thank you very much for your attendance.